Okay, recording.
Good evening, everyone. We are members of the Group 2. We are still under the topic Cadastral Survey Proceedings. Last time, part of Group 1's presentation is the summary of registration requirements and procedures, which include first, survey of the land, second, approval of the survey plan, and third, filing of the application. Tonight, we will continue the discussion on registration requirements and procedures, starting with setting the date of the initial hearing. Next slide, please. Within 5 days from the filing of the application, the court shall issue an order setting the date and time of the initial hearing of the application according to Section 23 of PD 1529 and LRC Circular Number 353. This court order shall be sent to the Land Registration Authority together with the following: application, duplicate copy; survey plan in tracing cloth, original or certified copy; technical description, original duplicate copy; surveyor's certificate; latest tax declaration; and proof of payment of publication in the official gazette. Note that the date and time of the initial hearing shall not be held earlier than 45 days nor later than 90 days from the date of the order. Next slide, please. The notice of application and hearing, its addressees are all persons appearing to have an interest in the land involved, including adjoining owners so far as known, and to all whom it may concern. Its content include requiring all persons concerned to appear in court at a certain date and time to show cause why the prayer of said application shall not be granted. The full technical description duly certified by the Bureau of Lands. Next slide, please. There are three means or modes of effecting notice of application and initial hearing. 1, publication; 2, mailing; and 3, posting or notice. In Republic versus Marasigan, there was a clarification regarding the modes of notice. The Supreme Court's Justice Davide explained that the proviso, provided however that the publication in the official gazette shall be sufficient to confer jurisdiction upon the court, does not mean that the requirements of notice by mailing and by posting are dispensed with. What is simply directed is that insofar as publication is concerned, there is sufficient compliance if notice is published in the official gazette. Although the law mandates that it should be published once in the official gazette and once in a newspaper of general circulation in the Philippines. Publication alone, however, would not suffice. This is to accord primacy to the official publication. Such proviso was never meant to dispense the other modes of giving notice, which remains mandatory and jurisdictional. It is obvious in Section 23 itself. If the intention of the law were otherwise, said section would not have stressed in detail the requirements of mailing of notices to all persons named in the petition who, per Section 15 of the decree, include owners of adjoining properties and occupants of the land. Next slide, please. Publication of notice. The notice of application and initial hearing is prepared by the Land Registration Authority. This shall be published in the official gazette and in a newspaper of general circulation in the Philippines. The additional cost of publication for every lot in excess of one lot shall be paid by the applicant to the clerk of court upon filing the application. The payment shall be remitted to the Director of the National Printing Office. Next slide, please. Purpose and effects of publication. What are the purpose and effects of publication of notice? 1, to confer jurisdiction upon the court over the land applied for. 2, to charge the whole world with knowledge of the land application. And 3, to invite those who wish to take part in the case and assert and prove their rights of the subject property. Next slide, please. Mailing of notice. When and to whom should notice of hearing be mailed? After publication in the official gazette, the LRA administrator shall mail this to every person named in the notice whose address is known within 7 days. And the law also provides for the mailing of notices to government officials. Here are some conditions such that select government officials are copy furnished. If the applicant requests to determine the line of public way or road, the LRA shall copy furnish the notice to the Secretary of Public Works and Highways, Provincial Governor, and Mayor where the land is situated in such municipality or city. For instance, if the tenant farmer has an adverse claim to the applicant, the Secretary of Agrarian Reform may be copy furnished. If the national government has claim adverse to that of the applicant, the Solicitor General may be copy furnished. If land borders on a river, navigable stream, or shore, or on an arm of the sea where a river or harbor line has been established, or on a lake, uh, Director of Lands, Director of Public Works and Highways, Director of Forest Management, Director of Mines and Geosciences, or the Director of Fisheries and Aquatic Resources may be copy furnished as may be appropriate. Next slide, please. For the posting of notice, the LRA administrator shall cause a duly attested copy of the notice of initial hearing to be posted by the sheriff or his deputy in a conspicuous place on each parcel of land included in the application and in the bulletin board of the municipal building of the municipality or city in which the land or portion thereof is situated at least 14 days before the date of initial hearing. Next slide, please. What is the effect of defective notice or defective publication? It deprives the court of jurisdiction. And if it has no jurisdiction, it lacks authority over the whole case and all its aspects. Next slide, please. Services of notice. Notices upon contiguous owners, occupants, and those known to have interest in the property shall be served by the sheriff. Failure of the applicant to give notice or post notice to potential claimants and include their names in the application for registration is tantamount to an omission. However, such omission cannot be deliberate misrepresentation constituting fraud, which serves as a basis for allowing a petition for review of judgment under Section 32 of PD 1529. Next slide, please. The filing of answer or objection to application. All persons, whether named in the notice or not, who claim ownership or interest in the land subject of the application may appear and file their answers or objections on or before the date of initial hearing in order for their claims to be heard and ventilated. Although, next slide please, although Section 25 PD 1925 apparently authorizes any persons claiming any kind of interest to file an opposition to an application for registration, the opposition must be based on a right of dominion or some real right independent of and not at all subordinate to the rights of the government. Next slide, please. What are the requisites for a valid answer? According to Section 25 PD 1529, the requirements for a valid answer, opposition, or objection to the application are as follows. 1. That it should be in writing. 2. That it should state the nature of the interest which the oppositor has in the property. 3. That it should state all the objections to the application. 4. That it should ask for specific remedies desired. 5. That it should be signed and sworn to by the oppositor, objector, or adverse claimant, or by another person in his behalf. And 6. That it should be filed on or before the date set for initial hearing or within such further time as may be allowed by court. Thank you.
Good afternoon. Good afternoon, everyone. Thank you, Mr. Balyentos. Uh, I'm here to report the property registration, the procedure of property registration, especially pages uh, 271 to 278. First of all, I would like to discuss the flow of what I'm about to report. We we're already the at the filing of opposition. Then after that, you have initial hearing, then trial, then judgment, then appeal, and if there's no appeal, then finality of judgment, then the entry of decree of registration. That's what I'm about to report. First, the Solicitor General is empowered to file opposition for the state. The Solicitor General represent the government in all land registration and related proceedings. Institute actions for the reversion to the government of lands of public domain and improvements thereon, as well as the lands held in violation of the Constitution. Order of General Default. Under Section 26, Order of General Default states that if no person appears and answers within the time allowed, the court shall, upon motion of the applicant, no reason to the contrary appearing, order a default to be recorded and require the applicant to present the evidence. By the description in the notice to all whom it may concern, all the world are made parties, defendant, and shall be concluded by the default order wherein where an appearance has been entered and an answer is filed, a default order shall be entered against person who did not appear and answer. That's called order of special default. That's what I'm about to discuss later. Effect of failure to file answer or opposition. When there's no answer or opposition to an application for registration in court, all allegations contained in the application shall be held as confessed by reason of absence of denial in the part of the opponent. A person who did not challenge the application cannot allege damage or error against the judgment of the land registration. A claimant having failed to present his answer or objection had forever lost his right in said land. In short, that's what we call estoppel. Order of special default, where an appearance has been entered and an answer or opposition is filed, a default order shall be entered only against all those persons who did not appear and answer. So, order of special default is only towards against several persons, several opponents who did not file their answer. Unlike general default, it it encompasses the whole world. Effect of order of default. A party in default shall be entitled to notice of subsequent proceedings, but not to take part in the trial. If a defendant fails to file answer on time, he may, upon motion of plaintiff, be declared in default. If he is declared in default, the court can proceed to render judgment, unless the court, in its discretion, requires the plaintiff to submit his or her evidence. Service upon party in default. No service of papers other than substantially amended or supplemental pleadings and final orders of judgment shall be necessary on the party declared in default, unless he files a motion to set aside the order of default, in which event he shall be entitled to notice of all further proceedings, regardless of whether the order of default is set aside or not. Relief from order of default. A party declared in default may, at any time after the notice thereof and before the judgment, file a motion under oath to set aside the order of default. upon proper showing that his failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. So this is the only remedy from an order of default. Hearing and presentation of evidence. The trial court is mandated to see to it that all registration proceedings are disposed of within 90 days from the date the case is submitted for decision. The applicant and the oppositor shall be allowed to present their respective proofs of claims or ownership during the hearing. Reference to a referee. The court, if it deems necessary, may refer the case or any part thereof to a referee who shall hear the parties and their evidence, and the referee shall submit his report thereon to the court within 15 days after termination of such hearing. Hearing before a referee may be held at any convenient place within the province or city as may be affixed by him, and after reasonable notice thereof shall have been served by the parties concerned. Courts in action on referee's report. The court may render judgment in accordance with the report as though facts have been found by the judge himself, provided, however, that the court may in its discretion accept the report of the referee, set aside the report in whole or in part of the referee, order the case to be recommitted to further proceedings. In short, the court can disregard the report of the referee if they may deem necessary. Factual evidence of possession and title required. The applicant must present competence and persuasive proof to substantiate his claim. He may not rely on general statements or mere conclusions of the law other than factual evidence of possession or title. So these land registration proceedings, especially the cadastral proceedings, you need to have documentary evidence. Unlike in other trials like criminal cases, um, they need witnesses or testimonial evidence or affidavits. In land registration proceedings, you need to have a documentary evidence such as title, certificate of titles, certificate of ownership, and or transfer certificate like that. So what applicant must prove before the court? An applicant for registration of land, if he relies on a document evidencing his title thereto, must prove not only genuineness of his title, but the identity of the land referred to. The document in such case is either the basis of his claim for registration or not at all. If he only claims a portion of what is included in his title, he must clearly prove that the property sought to be registered is included in the title. Promulgation of judgment by the court. After the hearings, the court shall promulgate its decision or judgment in favor of the person who has proven his ownership of the land subject of the proceedings. Judgment confirming title. Court's judgment shall contain a determination of all conflicting claims of ownership and interest in the land subject of the application. The judgment so rendered by the court shall confirm the title of either the applicant or the oppositor to the land or portions thereof based on his meticulous consideration of evidence presented as well as the reports of the LRA administrator and the director of lands, now appropriate DNR official, and its findings that the party in whose favor said judgment was rendered has sufficient title for registration. This only means that when the court held, when the court finished its adjudication, it must explain to both parties on why it arrived on that decision, giving them reasons and giving them why the title is rewarded to one party. It must the court must state its basis. Judgment dismissing the case without prejudice. If in any case without adverse claim, the court finds that the applicant has no proper title for registration, a decree shall be entered dismissing the application, and such decree may be ordered to be without prejudice. Meaning you can, without prejudice means you can refile. It means that the issue is still subsisting. Okay. An applicant may withdraw his application at any time before final decree, provided that in a case where there is an adverse claim, the court shall determine the conflicting interest of each parties, and after taking evidence, shall dismiss the application if neither of them succeeds in showing that he has proper title for registration, or shall enter a decree awarding the land applied for to such person entitled thereto. So this means that the court will mandatorily award a land title to one of the parties if it finds that are both parties evidence is not sufficient to prove that the title is theirs. Then they may dismiss the proceeding without awarding the title thereto. Import of the term without prejudice. When a lawsuit is dismissed without prejudice, it signifies that none of the rights or privileges of the individual involved are considered lost or waived. The inclusion of the term without prejudice in a judgment of dismissal ordinarily indicated the absence of a decision on the merits and leaves the parties free to litigate the matter in a subsequent action, as though the dismissed action had not been started. Therefore, a dismissal without prejudice makes it unnecessary for the court in which the subsequent action is brought to be determined whether that action is based on the same cause as the original action, or whether the identical parties are involved in the two actions. Purpose and effect of the term without prejudice. The purpose and effect of the words without prejudice in a judgment, order, or decree dismissing a suit are to prohibit the defendant from using the doctrine of res judicata in a later action by the same plaintiff on a subject matter. The doctrine of res judicata is based on the importance of the finality in law. If a court decides a case, the subject of that case is firmly and finally decided between the persons involved in the suit. So no new lawsuit on the same subject may be brought by the persons involved. Without prejudice gives a balancing. It gives both parties it gives both parties equal terms, because if there are no words without prejudice, if the court cannot dismiss the case with prejudice, then the defendant may use the doctrine of res judicata against the plaintiff. So it gives the defendant an undue advantage. So there you go. Court order for LRA to issue decree of registration. Judgment rendered in a land registration proceedings becomes final upon expiration of 30 days from the date of receipt of notice of judgment. An appeal may be taken from the judgment of the court as in ordinary civil cases. Once the decision has attained finality, the court shall issue an order directing the LRA administrator to issue the corresponding decree of registration in the name of the person whose favor the case was adjudicated. The court order for LRA to issue a decree of registration. The clerk of court shall send within 15 days from the entry of judgment a certified copy of the judgment, a certified copy of the order of the court directing the LRA administrator to issue the corresponding decree of the registration and certificate of title. A certificate stating that the decision has not been amended, reconsidered, nor appealed and has become final. Issuance and entry of decree of registration by LRA. After the receipt of the court's order, LRA administrator shall prepare the decree of registration as well as the original and duplicate copies of the original certificate of title, which shall be true copies of the decree of registration. The decree of registration shall be signed by the LRA administrator, entered and filed in the LRA registry book. Original copy of the OCT shall also be signed by the LRA administrator and shall be sent together with the owner's duplicate certificate to the registry of deeds of the city or the province in which the land is situated in his registration book. Original certificate of title. The OCT shall be a true copy of the decree of registration, and the decree is transcribed literally upon the OCT, meaning every word is transcribed. Period of LRA to issue this decree of registration. The LRA is mandated by law to issue the decree of registration within 30 days from the receipt of the copy of the order of land registration court for the issuance of the decree. Sending the copy of the decree of registration to the registry of deeds. The original copy of the OCT shall be sent by the LRA together with the owner's duplicate copy of the OCT to the registry of deeds of the city or province where the property is situated. Transcription transcription of certificate of title in registry book. The registry of deeds shall enter or transcribe the certificate of title in his registration book and issue the owner's duplicate copy of the OCT to the applicant upon payment by the latter of the prescribed fees. The entry made by the registry of deeds in his entry book is actually the original copy of the OCT, which entry is signed by him, the registry of deeds, and sealed within the seal of his office. Thank you.
To continue our report, I will be discussing the important points and principles regarding the issuance of certificate of title. Next slide, please. As discussed by Mr. Bautista, that after the issuance and of a decree of registration by Land Registration Authority or the LRA, the next step is to send the copy of that decree to Registry of Deeds, which the RD shall then cause the transcription of the certificate of title in the registration book and issue the owner's duplicate copy of the original certificate of title to the applicant upon payment of the prescribed fees. The following are the procedures in preparing the decree of registration and certificate of title. The court which rendered the judgment directing the registration of title to land shall, within 15 days from entry of judgment, issue an order directing the Land Registration Authority Administrator to issue the corresponding decree of registration and certificate of title. Next slide, please. Then, the clerk of court shall send to the LRA within 15 days from entry of judgment a certified copy of the judgment, a certified copy of the order directing the LRA administrator to issue the corresponding decree of registration and certificate of title, and a certificate stating that the decision has not been amended, reconsidered, nor appealed and has become final. Next slide, please. um, Pursuant to Section 39 of PD 1529 or the Property Registration Decree, the LRA Administrator shall cause to be prepared the decree of registration as well as the original and duplicate copies of the corresponding original certificate of title, which shall be a true copy of the decree of registration. The decree of registration shall be signed by the LRA administrator and shall be sent together with the owner's duplicate certificate to the RD of the city or province where the property is situated for entry of transcription in his registration book. Next slide, please. In the case of Republic of the Philippines versus Lourdes Abiera Nilas, where the court was called upon to decide the merits of the case and to apply the provisions of PD 1529. The facts of the case are as follows. Lourdes Abiera Nilas filed a petition for revival of judgment with the RTC of Dumaguete City. It alleged that on July 17, 1941, the CFI of Negros Oriental, acting as a cadastral court, rendered a decision adjudicating several lots together with the improvements thereon. in favor of the oppositors who had established their title to respective lots and their continuous possession since time immemorial, and ordered the chief of the General Land Registration Office to issue the corresponding decree of registration. One of these lots was adjudicated to both Kalingkasyon. Nila's parents, by way of a deed of absolute sale, acquired the said lot through various purchases they effected from both Kalingkasyon and her heirs between the years of 1975 to 1982, as evidenced by the three separate deeds of absolute sale in favor of Nila's parents. The RTC finds merit in the petition for revival of judgment and ordered the revival of the 1941 decision, as well as directing the Commissioner of the LRA to issue the corresponding decree of confirmation and registration based on 1941 decision. However, the CA held that the provision of Section 6, Rule 39 of the Rules of Civil Procedure, which imposed a prescriptive period for enforcement of judgments by motion, refer to ordinary civil actions and not to special proceedings such as land registration cases. Hence, in the present petition, the OSG strongly argues that contrary to the opinion of the CA, the principles of prescription and laches do apply to land registration cases. The OSG notes that Article 1144 of the Civil Code establishes that an action upon judgment must be brought within 10 years from the time the right of action accrues. Further, Section 6 of Rule 39 of the Rules of Civil Procedure establishes that a final and executory judgment or order may be executed on motion within 5 years from the date of its entry, after which time it may be enforced by action before it is barred by statute of limitations. So the issue in this case is whether or not prescription or laches may bar a petition to revive a judgment in a land registration case. The Supreme Court held in negative. It ruled that the Property Registration Decree or the PD 1529 does not contain any provision on execution of final judgments. Hence, the application of Rule 39 of the Rules of Court does not specifically provide for execution of judgments in the sense ordinarily understood and applied in civil cases. The reason being there is no need for the prevailing party to apply for a writ of execution in order to obtain the title. That Rule 39 of the Rules of Court is not applicable to land registration cases in the first place. Next slide, please. Besides, Rule 39 as invoked by the Republic applies only to ordinary civil actions, not to other or extraordinary proceedings not expressly governed by the rules of civil procedure but by some other specific law, such as the land registration case. Unlike in ordinary civil actions governed by the rules of civil procedure, the intent of land registration proceedings is to establish ownership by a person of a parcel of land consistent with the purpose of such extraordinary proceedings to declare by judicial fiat the status, condition, or fact. Hence, upon the finality of a decision and a ministerial duty exists, unlike on the part of the Land Registration Court, to order the issuance of and the LRA to issue the decree of registration. Next slide, please. Clearly, the peculiar procedure provided in the property registration law from the time decision in land registration cases become final is complete in itself and does not need to be filled in. From another perspective, the judgment does not have to be executed by motion or enforced by action within the purview of Rule 39 of the 1997 Rules of Court. Applying these premises in the case at hand, there would have been no need for NILAS to file a petition for revival of judgment, since the latter is a procedure derived from civil procedure and proceeds from the assumption that the judgment is susceptible to prescription. The primary recourse need not be with the courts, but with the LRA, with whom the duty to issue the decree of registration remains. Again, next slide please. Again, the provision of the rules of court on the enforcement of judgment does not apply to special proceedings such as land registration. Next slide, please. In special proceedings, the purpose is to establish status, condition, or fact. In land registration proceedings, the ownership by a person of a parcel of land is sought to be established. After the ownership has been proved and confirmed by judicial declaration, no further proceedings to enforce said ownership is necessary, except when the adverse or losing party had been in possession of the land and the winning party desires to oust him therefrom. Next slide, please. With regard to procedure after judgment and issuance of certificate of title, Section 39 of PD 1529 lays down the procedure that interposes between the rendition of the judgment and the issuance of the certificate of title. No obligation whatsoever is imposed by Section 39 on the prevailing applicant or oppositor even as a precondition to the issuance of title. These are the obligations provided in said section are levied on the Land Registration Court to issue an order directing first the LRA administrator to issue in turn the corresponding decree of registration. Next slide, please. Second, its clerk of court to transmit copies of the judgment and the order to the LRA administrator, and lastly, the LRA commissioner to cause the preparation of the decree of registration and the transmittal thereof to the RD. All these obligations are ministerial on the officer's charge with their performance and thus generally beyond discretion of amendment or review. Next slide, please. Next slide, please. Slide number 52. There is no additional burden to be imposed on the owner after judgment. As shown in the screen, it states that the failure on the part of the administrative authorities to do their part in the issuance of the decree of registration cannot oust the prevailing party from ownership of the land. Neither the failure of such applicant to follow up with said authorities can. The ultimate goal of our land registration system is geared towards the final and definitive determination of real property ownership in the country, and the imposition of an additional burden on the owner after the judgment in the land registration case had attained finality would simply frustrate such goal. Next slide, please. Concerning post-judgment remedy to recover possession of land, the remedy of a successful party in a land registration case is to ask the court for a writ of possession to place him in possession of the property. So, what is a writ of possession? A writ of possession is a writ of execution employed to enforce a judgment to recover the possession of land. It commands the sheriff to enter the land and give possession of it to the person entitled under the judgment. Next slide, please. However, contempt is not available in case of refusal to writ of possession. In the case of Rom versus Cobadora, it states that in case of refusal or unwillingness on the part of the defeated party to relinquish the property would not constitute contempt. The proper procedure must be followed in the execution of judgment. Next slide, please. So under Section 10, Paragraph C of Rule 39 of the Rules of Court as amended, it is not for the sheriff in the enforcement of a judgment for delivery or restitution of property to merely direct the defeated party to effect such delivery or restitution. The refusal of the defeated party to surrender the sheriff does not constitute contempt. The sheriff himself must oust the defeated party from the property and effect possession of the property. Next slide, please. But there are instances when losing party may be punished for contempt, like in the case of Ch- Chines Commercial Property Corporation versus Martinez, which provides that if subsequent to such dispossession or ejectment, the losing party enters or attempts to enter into or upon the real property for the purpose of executing acts of ownership or possession or in any manner disturbs the possession of the person adjudged to be entitled thereto, then and only then may the loser be charged with and punished for contempt. Next slide, please. A special order for removal of improvements is necessary. This can be done through a writ of demolition. Under pursuant to Section 10, Paragraph D of Rule 39 of the Rules of Court, as amended, it explains that if to place the winning party in possession, the sheriff has to remove an improvement made by the defeated party. He cannot do so unless upon special order of the court issuing the execution. And this order may be granted only upon motion of the plaintiff with notice and after hearing and upon the defeated party's failure to remove the improvement with the reasonable time given him by the court. Next slide, please. So, the writ of demolition, a complement of writ of possession. If the writ of possession issued in a land registration proceeding implies the delivery of possession of the land to the successful litigant, a writ of demolition must likewise issue, especially considering that the latter writ is but a complement of the former, which without said writ of demolition would be ineffective. Next slide, please. The Land Registration Court has the power to issue all auxiliary writs of demolition, processes, and other means necessary to carry into effect the jurisdiction conferred upon it by law in land registration cases to issue a writ of possession to the successful litigant. Next slide, please. It should be noted that the issue of decree of registration after judgment is not a ministerial act. This principle elucidates in the case of Laborada versus Land Registration Authority. The facts of the case are petitioner's spouse's laborada applied for the registration of a lot which was approved by the trial court. Upon motion, the trial court issued an order requiring the LRA to issue the corresponding decree of registration. However, the LRA refused. Hence, petitioners filed an action for mandamus. The, the LRA revealed based on the records that Lot Number 3A, which sought to be registered by spouses laborada, is part of lot number 3, over which a transfer of certificate of title has already been issued. Also, it contended to issue the corresponding decree of registration sought by the petitioners, it would result in the duplication of titles over the same parcel of land. So the issue in this case is whether or not the LRA may be compelled by mandamus to issue a decree of registration. The ruling of the court was in the negative side. It is settled that the Land Registration Court has no jurisdiction to order the registration of land already decreed in the name of another in an earlier land registration case. A second degree for the same land would be null and void since the principle behind original registration is to register a parcel of land only once. Thus, if it's proven that the land which petitioners are seeking to register has already been registered in 1904 and 1905, the issuance of decree of registration to petitioners will run counter to said principle. The issuance of decree of registration is part of the judicial function of courts and is not mere ministerial act which may be compelled through mandamus. It is not legally proper to require the LRA to issue a decree of registration. Next slide, please. The issuance of decree of registration is not compellable by mandamus. It is well settled that the issuance of such this decree is not compellable by mandamus because it is a judicial act involving the exercise of discretion. Likewise, the writ of mandamus can be awarded only when the petitioner's legal right to the performance of the particular act which is thought to be compelled is clear and complete. Next slide, please. Uh, it is recalled that a certificate of title is an evidence of an indivisible title and ownership. A certificate of title serves as evidence of an indivisible and incontrovertible title to the property in favor of the person whose name appears therein. The real purpose of the torrent system of land registration is to quiet title to land and put a stop forever to any question as to the legality of title. Land registration under the torrents system is a judicial proceeding, therefore final and binding. Therefore, a registered title cannot be altered, modified, enlarged, or diminished in a collateral proceeding and not even by a direct proceeding after the lapse of the period prescribed by law. Next slide, please. In addition to that, it is well established principle that a tax declaration cannot prevail over a certificate of title. As shown in the screen is a sample certificate of title and tax declaration. Next slide, please. The tax declaration and tax receipts cannot prevail over a certificate of title, which is an incontrovertible proof of ownership. They do not by themselves conclusively prove title to the land. The payment of realty taxes cannot by the applicant be a sole and sufficient basis for the grant of the properties to them. Tax declarations are not conclusive evidence of ownership but merely indicia of a claim of ownership. The open, continuous, exclusive, and notorious possession in the concept of an owner is a conclusion of law, and the burden to prove it by clear, positive, and convincing evidence is on the part of the applicant. A claim of ownership will not prosper on the basis of tax declarations if unaccompanied by proof of actual possession. So this ends our group presentation. Thank you for listening.